All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you, Mr. Ramos. Good morning, Council. Please be seated. I'd like to welcome you to the 3rd Court of Appeals as a home away from home for the 7th here on cases by transfer. And pleased to announce that you are not the first, but the second case to hear live oral arguments in this courtroom in more than a year. So we're glad to bring oral arguments back to the 3rd Court of Appeals. The case scheduled at this time is called number 0720000184CR. Jared Latta versus the state of Texas. Is the appellant ready to proceed? Yes, sir. You are Scott? Yes, sir. Great. And is the appellate ready to proceed? Yes, sir. And you are Mr. McPhee? Yes, sir. Counsel, if you have not been so informed, panel before you today is consists of myself. I'm Justice Earl. I've been with the court for a number of years. And to my right is Justice Judy Parker, and to my left is Justice Larry Lawrence Goss. As most courts, we have had the opportunity to review the briefs, but have not necessarily reviewed the records. So we may have some questions about the facts of the case. We have allotted each side 20 minutes for your arguments, with the having an additional 5 minutes for rebuttal. Please don't read anything into our questions. Oftentimes, our questions are designed to just test some questions that we may have, theories that we may have about the case, not intended in any way to reflect the ruling for the disposition of the case or the pleading. So, with that, I also announce that we are broadcasting this somewhat limited on YouTube, limited, I say, by our technology. The 3rd Court of Appeals doesn't have the same equipment that we have in Amarillo, but that is available, and it will remain available for some time. Probably how long? Forever. For the time being, you'll be able to access these arguments later to review arguments. With that, I'll allow the appellant to begin presentation.
Please support. In thinking about the opportunity to discuss this, there are several issues that are unique in this case. Ranking oral arguments. I'm happy to address the error in criminal order reports, which is, if not, I will begin with error number 6. Chronology is that it was the motion to quash the charge. In that applicable paragraph, the state chose to merge 2 separate offenses into one charge, specifically provisions of 3903A, that's Penal Code, 3903B. First of which, both of which are impression, the first of which deals with arrest, detention, that nature. B specifically talks about rights dispossessed, pride. Now, that is one of the first error that was complained of in the motion to quash, properly brought up well in advance of trial, brief, analyzed, hearing held, that only exacerbates the core problem, and that is unlawful. What is or was alleged to be unlawful as required under the additional person statute? It does not delineate any act that was unlawful. In its definition, what is unlawful? Something that's criminal or tortious. The state relies on 1.07A78, the definition of unlawful in this regard, in their argument that it should not or does not need to be delineated or alleged in the charging instrument. But then disavows that in its earlier argument in support of the instructions or lack thereof regarding the justifications. The definition of unlawful specifically speaks to acts that are not otherwise justified or privileged. Now, I will go on, the state's logic, unfortunately, if this statute, or this allegation were held to be sufficient, the notice that's required, it would then make any unreasonable, later to be determined unreasonable search, detention, arrest, stop, anything that is later to be determined by a court to be unreasonable of the Constitution, and therefore as what we call illegal, although technically not illegal, it is simply unconstitutional, and therefore would trigger exclusionary rules. By their logic, it would make any law enforcement officer or judge or anybody involved subject to criminal liability. That is dangerous ground to tread when we're talking about constitutional rights. And we are empowering police officers to discharge their lawful duties of stop, detention, search, and arrest.
Yeah, I suppose the whole theory of prosecutorial discretion, we're talking about the issue of it being so broad, cover any act law. It's going to prosecute only in those situations where prosecuting authority finds it to be sufficient to it's not going to happen often. So we think
Certainly.
and what is it about this case that transcends that? Almost state question.
I'm not sure if I can answer that question. Not me find that question. And so I can only surmise. I believe that the rationale of the state, and I think it's reflected in their argument, presentation of evidence, was that their theory was that the defendant, the appellant, should have known that an arrest would later be determined or potentially determined unreasonable if informed in their that's the rationale that I saw in the record and in the presentation of their evidence. There was much of the record contains opinion evidence by experts about the law and whether they thought things, certain elements of it were considered to be unconstitutional or therefore illegal. And it was all opinion based. And the argument was that based upon the training of the officer, he should too know all of the constitutional constraints and intricacies and nuances of the law when making the arrest. or if he is wrong in his understandings or opinions. Therefore, he would be subject to criminal liability. That's a very high standard to place on a police officer on the street. In this particular case, it goes even more so because the appellant was not the primary officer making those determinations and was late to the scene and was only assisting.
Ask you a question related to what you were saying just a minute ago. Under the official oppression statute that acts the Constitution. Is that an objective standard specified? Is that you have to show some sort of subjective intent, or is it simply these are the acts you violated? Therefore,
Under the statute, the way it was pled, that it was subjective to the mind of the officer, that he knew what he was doing was unlawful at the time. Therefore, at the time he was arresting somebody, he would have to have the knowledge that what he was doing was in fact unlawful, or as we are now interpreting it, unconstitutional. Now, an unconstitutional violation is not unlawful under the statute. Definition of lawful, unlawful, criminal, or tortious. Arrest is not included in penal code, criminal procedure. It's not delineated. And therefore, it's not a criminal act. It could be, yes, tortious if argued in some way, as far as civil rights type of statute, federally, but not a state.
is evidence of good faith relevant to the analysis?
I think it would be, such as say a search warrant, good faith exception of a search warrant, or an arrest warrant, in searching a particular place or based upon a search warrant, an officer or the search in and of itself is converted from a, in fact, unreasonable search. It is then justified by the officer's good faith reliance. I think it could have a place in this rationale, but that is overarching the underneath problem that there was no unlawful act pled in the indictment, and that was our argument, that the indictment should stay. It should be quashed because it does not give the appellant the knowledge or notice of what it is the state is saying was in fact unlawful. And that opens the door. And that's the problem, because the state suggests that they do not have to plead a specific unlawful act. Problem B specifically states that all should be pled, and under the Colossians v. State which is as cited, they both support that all elements, should be pled in the indictment to give proper notice. And that's where the problem comes. That opens the door to this for the state to then plead just simply there was an unlawful act that occurred, and then later at trial prove or attempting to prove or put on evidence of whatever they wish later and argue everything.
Well, if I recall, what the indictment alleged that Friday, made three unlawful arrests on 40.
Yes, sir.
So, I mean, that's not necessarily a very specific, more specific than
And I agree with that, Your Honor. That goes to the subjective nature of it. Did he know it was unlawful at that time? The problem being, the state at trial argued, put on evidence, other unlawful acts, such as trespass, such as assault, such as conspiracy, and charging and arguing with the law of parties, that this officer was held accountable to the actions of other officers and their knowledge of whether or not it's an unlawful act. None of that was pled, and therefore the appellant was penalized and not able to adequately prepare for exactly what the state was alleging was in fact the unlawful act. And that's why the indictment in this case should fail. Doesn't give adequate notice. My time is running out quickly. I would like to also briefly discuss area number 1 and 2, which is jury formation. Unless the court has questions on it.
Yes, I'll be glad to grant you your time. In preparing for this case, I couldn't help but contemplate the George Floyd and think about how a statute such as this might be used in prosecution of police excessive force. And that's where I originally looked at my question of prosecutorial discretion and what role the prosecutorial discretion plays in cases such as this. Philosophical.
Well, philosophically, I believe that if a specific act, unlawful act is pled, certainly they can be available and justified. I can also glean just from my years of experience in these types of cases, that prosecutorial discretion allows the state to also charge a police officer, not under the official oppression statute, yes, but for any felony offense, individual, such as aggravated assault, murder, would be available to the state if they chose to prosecute a police officer who has, for instance, brought about the death of an individual if they felt that the evidence supported a murder charge. They certainly have that discretion to do so. Official oppression is not the only available avenue. But in the official oppression statute, there must be that unlawful act. They could charge official oppression by committing murder. Not sure why that they would. They could. And under this statute, philosophically, that's why I feel that it very well could open the door and provide prosecutorial discretion far beyond what the intent of the statute was to police make sure that they were not committing unlawful acts in the course of their discharge under a lawful discharge of their duty. A remedy, and I believe what is necessary, is that in the charging instrument, it details what unlawful act the state is alleging. That's where the deficiency lies in this charging instrument, as we raised well in advance of trial.
Gentlemen, time that you looked at how this case got off track.
Unfortunately, a lot of that is off record. I can tell you that you have two trial lawyers who tried the case before the court arguing today. So we do have, this is sometimes unusual in an oral argument, knowledge. The record reflects that, and prior to the selection of jury formation, when it is referenced by myself and the court of the off-the-record conversations about that. And I, as the record reflects, chose to bring that up on the record to ensure that our objection was lodged. I feel philosophically that this is a structural error, while it is not a federal constitutional structural error. It is a constitutional, Texas constitutional right to be tried by 6 jurors when it's a misdemeanor. Tried in district court.
You made that argument in your brief, but I don't think I ever read any authority that you cited to say that it's constitutional errors.
There is it is an unusual constitutional difference in that it confers a right, a trial right to a defendant that is not necessarily covered in the federal code. It is a situation where our state has decided to provide additional protections. Certainly, states can do. They can provide additional rights that cannot dilute the federal rights. This is one of those situations.
If you had 6 jurors, if you had a unanimous jury, I'm trying to figure out how there was harm in what occurred.
And I
Because
will,
it would have included the 6 jurors
Yes.
who would have been restricted to hearing the
of
case.
course, and I will say that. Allow me just a moment. Our legislature thought that it was important to provide an individual who's charged with misdemeanor, tried in the district court, additional protections. The additional protections is laid out in error number 2, which is you're provided 5 strikes as opposed to the normal 3 in a misdemeanor. So our legislature clearly has decided that an individual in that position should have additional strikes in the formation. Now, to your question, I think it is dangerous to apply a harmless error standard when it is a constitutionally conferred right. I think that is ground that should not, it does not apply. However, it's plowed. The problem that what is cultivated from the plow is the harmless error analysis. And in my opinion, that harm is unknown because it's behind the jury. And
Your time is up. Bernard, why don't you take a minute to wrap up what you're
yes, sir. 2 points I'd like to cover. I'd like to just finish with that just for a moment. From a trial lawyer standard perspective, in that situation, you have 6 additional people back there deliberating that otherwise would not. And let's say the first vote was 6-6, both ways. And it just so happens those additional 6, they think it should be for guilt. And they spend the next 2 days deliberating and arguing their position, and the other 6 swing their way. There's where the potential harm stands. It would never be proven because we can't go back there and talk to the jurors about how. And so it would be harm that we would never really be able to assess. Like the second point, the problem in this particular case is it was exacerbated because not only was the appellant forced to pick a 12-person jury when the Constitution says 6, but he was further limited to only 5 strikes in picking a 12-person jury. Therefore, additional people were placed on that jury that may not otherwise. We typically talk about juries 9 and 10 that were seated. That had there been the other 5 strikes that we should be at, if it were not in district court, would have been strict. Yes, yes, to both of these issues. It was brief. We objected. The judge was clear that he understood the objection and reaffirmed that it was his opinion that it would be 12 jurors with 5 strikes. And we asked for additional strikes to hopefully even remedy that error, which we were doing. There are other issues, obviously, in my brief that I hope the board also considers. Those 2, I feel, are the 2 that are the most unique. A lack of guidance, especially the motion of law. However, the guidance in the jury formation are things. Thank you very much for the opportunity to argue.
Please, court. Thank you very much for being here on the 3rd floor of your case. That's appreciated. I'm Sonny Mack, the district attorney in 33rd, which includes 4 counties, one of which is Latta. I would like to start with just the last question. Justice Parker, I believe you asked if there was an objection. I understood that means, was there an objection to those 2 jurors? No, there absolutely is no objection to those jurors. In fact, one of the jurors, juror number 9, was brought to the bench and asked some questions. And Judge Stubbs asked appellant's counsel, "Do you have anything else?" And he said, "No, no more questions." Number 10 was asked a question on page 119 of the transcript before the hire. And she said that she thought police officers that did illegal searches ought to be prosecuted for it. And there was no other question until 133, when there was plenty of time to question. So there were no objections or errors preserved in regard to those.
You have to make objections to specific jurors when the request is for a regulatory challenge instead of a four-point.
You don't have to, but you claim that there's error because you were not able to question those jurors properly and had to use a regulatory challenge when you're back running through the challenges. It needs to be clear so the judge can clarify. If he needs to have to know about it when he's got the time to do something about it. And there was no notice of that. Jury number 9, which is Bruce, 5 strikes. And in addition, addressing the 5 strikes, that's statutory in 3515. That there'll be 5 strikes for misdemeanor court and difficult. When you have a misdemeanor in this court, 3515 is the C, I think it is. So you'll have 5 strikes. So that was fine. There was a number of jurors that was an issue. And so we had 12 jurors. Our first position on the state part is that error wasn't preserved, especially constitutional error that somebody might claim, because the objection, the judge said within the statutes, it says here that but it says here that the first 12 will be seated, the word calls their name after the strikes. Judge said, that's what it says here. Anytime in district court, and then it says that there will be 5 strikes. So problem is that the amendment of the Constitution and the legislation that went along with it that was changed in 2004 didn't reconcile the provisions we already had prior to 2004. It was always for misdemeanor district court. It was 12 years, 5 strikes. That's what it was in 2004, 38 years. So the judge says, okay, we're having 12 jurors as I read it, and we're going to have 5 strikes each. And then there was a discussion about the strikes. Then appellant's counsel said, well, for safety's sake, I'm going to go ahead and object. But this was after the objection about the number of strikes, because the preceding statement to that was, if the court is going to seat 12, then I want 10 strikes, or we would request 10. There was no objection saying we don't seat 12. Say, well, my experience, it's 6 years. So it wasn't clear exactly what that objection was, but given the benefit of the doubt that, yeah, the image cover strikes as well as number of jurors, go to the court act. When we're getting ready to make strikes, judge asked both of us, said, you're gonna have 5 strikes, this is where the strike line is, this is where the open strike line is. You okay with that statement? We're okay with it, yes. How about the fence? Yes, sir. Now, is that a waiver? Well, we've got, I think, got to look at the full record. Justice Burke said at the top of it, you know, it's not done in the back, I'm paraphrasing, great. You got to look at the full record. Well, the next record is, when you get ready to see the jurors, was there an objection? Is there any objection to this jury being seated? State didn't have an objection, and the answer from the defense was no, Your Honor. So there was an opportunity, if you thought there was error, and it was never pointed to constitutional error, to cure that, give the judge a chance to cure it. That was never done. It was never done. And we had trial for 4 days. So there was plenty of opportunity. 18 days after the end of the trial, we had a punishment phase. There was a motion for retrial. It was filed. And it wasn't presented. But there's nothing in the record show was ever presented. There was no order attached to a proposed order. There was no request for a hearing. There was no hearing held, and there's nothing in docket sheets or any document seen in the record show that was presented. That motion for new trial complained of the 12 jurors, but statutorily, there was never a complaint about the Constitution. So even with the motion for new trial, had it been presented, the judge still was presented with an opportunity to cure anything that might be an issue. The only time that was brought up was here. So 12 jurors harmed, it fell without verdict. If anybody would complain about that, I think it'd be the same. But our position is when you look at the whole record, that was made. Because once board hour is accomplished, each side knows who our jurors are going to be, or at least we know who we're starting. And when you see the jury being seated, and you know who's sitting there, you know who to talk to and what the results are. That is a perfect place if you're going to complain about the 12 jurors to do it. And that being the case, once the council's had an opportunity to determine who's going to be sitting in front of them, the state's got to put 12 people instead of 6, then that error is waived when nothing is given to the judge to correct it. Because now you can use it to your advantage to say, okay, now they've got to convince 12 instead of 6, and there wasn't an objection. For the waiver again, motion for new trial, we have constitutional issues in it, so our position is waived, and then go to harm. You know, the Ballou versus Georgia case is cited in the state's brief. I think that's a real good case to look at because it's a 1978 case that they talk about that larger juries inure to the benefit of the defendant because there are more people to remember the important things. There are more deliberations. You get better deliberations, and they cited some studies in there where it was determined these things were determined, and they gave statistics on there are less jurors with smaller numbers. You get 12 numbers, you get greater due process than 6. So showing harm, there is no harm. There's no harm that has been shown. That's it. And if we can analyze it under 44.2a, it's very beyond a reasonable doubt. The state's burden is double. When you have more jurors, you've got to get to the deliberation. That it's beyond a reasonable doubt. There's no harm to the defendant. The damage is to the state. Error, yes. It's personal error, no. Proven it is a constitutional error, no. It's not a constitutional right to have a 6-person jury. So our position is first, didn't preserve, but given the benefit of the doubt, yeah, there's preservation there. But certainly wait in the conduct. Justices, are there any questions? Okay. With that, then I'll go to the indictment. Counsel said that it opens it up to any constitutional violation or anything that goes wrong, and a police officer could be held accountable. So there's a big difference. The difference, there's only that type of accountability, and it's under the statute 3903, official oppression. When the officer engages in the deprivation of a right, and he knows he's doing it. He knows it's unlawful, and he knows he's doing it. That's where the culpability comes in. Great question about how cases rise to this level, how you get to a case like this. And I would urge you to look at States 3, the video of the arrest of Mr. Corey Nutt, because this is about an off-duty officer that lived in an RV park next to Mr. Nutt, and he spends his tires going out to a call late in the evening. Mr. Nutt hollers at him. He's standing outside his trailer, hollers at him. They have some drinks, and he tells the guy to slow down. The guy stops. He's in a rush. He says to go to call to stop. And tells Mr. Nutt, I'm on a call. He says, well, we got to get out here slow down. So they get him a few words. Officers come back. Eventually, 4 officers end up in Mr. Nutt's trailer there in an RV park. On a public intoxication call, that's what we're talking about, public intoxication call, and Mr. Nutt is in his house, and he's seen in State 3, and 4 officers stand out there for about 15 minutes, 2 of them, you can see the video, trying to cajole him, trying to threaten his job, threatening all sorts of things to get him to come out, so they can arrest him for public intoxication. When that doesn't happen, the chief of police walks in, puts his hand on the back, says, go on. And this is on his back. Mr. Nutt says, I don't want to come. This is my home. I'm inside.
That was a public present. That time was what time the encounter.
Well, according to the testimony of Amy Shannon, who actually testified for the defense more than the state, what Amy Shannon testified that got there 5 minutes after she did, and she got there, turned on her video camera. As soon as she got to the scene, Officer Harden had been there for a few minutes before that, but Amy Shannon turned on her video camera. And you see, appellant, as a chief to say, go out, puts his hand on his back, arrest, tells him to go out. Appellant's bottom of the stairs and says, come on down out of there, or if you don't, I'm coming in, and you're not going to like the way I. And so they handcuffs, they take him away, and that's where we get to the indictment. The indictment is fled, gives notice because it's not emerging. The state's logic, as counsel put it, is not exactly that. The state's logic is to track the statute. The statute says it's official oppression and you deny somebody a right. So where do we go for the rights? The best place I've found is Bill of Rights of the Texas Constitution, Article 1, Section 19, which says you cannot deprive somebody of their liberty without due process or due course of law. So that's what we allege. And we allege that knowing it was unlawful, appellant deprived according to a due process of law, I seizing, arresting, and detaining. We have alleged 2 offenses. It's 1 offense, official oppression. Now, the proof of that, again, counsel said that we've got to prove that there's unlawful conduct. Well, an arrest is unlawful if you can criminal charges. It's a violation of the 4th Amendment. Counsel said that violation of the constitutional amendment is not a criminal offense. I disagree. So we have a lot of criminal offenses that rise out of a 4th Amendment violation. Most of the times they're not, unless the officer knows what he's doing is unlawful. That was a burden the state had. That was what the jury found, and that's what the charge gave to the jury to find. They had to find it was unlawful conduct. Now, the counsel said that for appellant said that it opens wide up any violation. But it could, if you deprive somebody of the right, if you make an unlawful arrest, knowing it's an unlawful arrest, that's the first area. Denying the rights, sexual arrest, which is not relevant at all. But the fact that we use some of the words that are in the paragraph A doesn't mean confuse anybody when it comes to by arrest, seizing, and detaining without due course of law. Because to go inside, they needed either warrant, taken circumstances, somebody's consent to go in. Council talked about probable cause. A couple of the errors are definitions, probable cause, collective knowledge doctrine. not only crux of the state's case, and what the cause was not an issue. Collective knowledge doctrine was absolutely irrelevant because let's assume for the sake of argument that they had probable cause that Mr. Nutt was intoxicated. And that was a discussion of that. That's not the issue of course in this case. The proof showed that when they went inside his home, his castle, it's Garrett Matlock. Garrett Matlock was our expert that testified to a lot of the legal principles as well as practical. She's defended officers for 30 years. It's all in the transcript. And that's another good thing to read. Is her testimony kind of gives an outline of what this case is about and how it rises to this level to be prosecuted under prosecutorial discretion. The entry into the home without knowing that it was public intoxication, and as one of our witnesses said, it's kind of like police in 101. Everybody knows you don't arrest somebody for public intoxication out of their house. Even if they had a problem cause, they could go in and inside without a warrant, without taking circumstances.
So, and I think that's the question that I would ask the council.
Yes.
Is it your position that it's a subjective standard then? Do we look at whether somebody subjectively did that? Or is it your burden to show that anybody under the circumstances would have done this?
Thank you. That's a great question. I appreciate the question. The statute actually, in my opinion, has two. You've got a subjective element, you've got an objective element. One was there unlawful conduct. That's an objective standard, whether it's unlawful conduct. But the most important is the subjective aspect of it is, did this defendant know it was unlawful? It's purely subjective. It's what did this person know, not what he should have. That would take it out of, that takes out of.
That's for the first prong, or whether it was unlawful conduct.
Yes.
It has to be, I'm assuming it's got to be prospective unlawful. It's got to be something that has to be illegal and on the books and established at that point, versus we find out later on that the person who got arrested, his conviction got set aside because it was a bad search, and that serves the basis for the illegal activity. I think that's what opposing counsel was challenging just a minute ago, was to say, if you take a retrospective look, if that becomes your evidence of unlawful conduct, doesn't that create a slippery slope that any police officer is potentially criminally liable? Because guys in black robes or women in black robes decide that something is unconstitutional.
As you phrase it, yeah, that would be a slippery slope. As the facts are in this case, and as the law is, no, it's not a slippery slope at all. It's when that officer knows at the time he's engaging in the unlawful conduct that's in the law. That's what makes it an offense. Otherwise, you would have an arrest instead of a granting of a motion to suppress it. It's apples and oranges. If someone violates the Constitution or violates a statute to the detriment of someone's rights and knows that it's unlawful when they do it, that's what stops the slippery slope. That's the big distinction between a motion to suppress where evidence is suppressed and an offense by a police officer. A police officer, and I believe Justice Dawson, I think he said, does good faith, is that relevant? Of course, it absolutely would be relevant. Good faith would absolutely be relevant because it's not good faith. We can't prove, I can't prove the trial that he knew his conduct was unlawful. So that's inferentially resolved by the jury when we present the evidence and show that he knew his conduct was unlawful. We proved him that. Now, saying that the law parties holds him accountable for someone else, even if he doesn't know what's going on, so that's just not an accurate statement of the law, because of the law parties, again, you have to intend that the unlawful conduct occur. So even under law parties, you're still responsible for the conduct of others only if you aid, direct, assist, or attempt to do those things while the intent that the unlawful act occurs. So that doesn't make somebody responsible. Like under 602, when you get criminal responsibility for someone else, that's the main thing about the official versus statute. And what causes one case to rise above another in prosecutorial discretion. To answer the question, Justice Dawson. See, I've got a minute and a half here, a little more than a minute and a half. again, would urge you to look at states that are, would urge you to look at your test kind of synthesizes, along with kind of synthesizes a lot of the issues that were in there. Research that the jurors that were not talked to, those jurors were talking in the opportunities there, so that's not really a good indicator, I don't believe, of any court hour form. And the questions that were presented were not proper questions. Court hour, that's covered with the brief, so I'm belabor that. 20% of it was going, they have somebody on a scale of 1 to 10, I think we level was. So it was prolonged. We all had the same opportunity. Another thing on waiver of the 12 jurors or number of strikes is the judge says at one point, when challenged on whether she could take the 12 or not, he said, you know, that's exactly what I thought about 6 jurors. That's exactly what I thought when you asked me last week until I let it go. So apparently there's plenty of opportunity. I don't, certainly it's not in the record what it was. As counsel said, a lot of the things we did were off the record, but the judge refers to that as being a week. Well, there's nothing in the record to show that that was ever brought up or did address. So somebody had plenty of time to think about it. That's why we say there's a strong argument for waiver when you look at the entire. And I believe there was a waiver. If there are any questions I can answer, I see I'm out of time anyway. But if you have any questions at all,
Council, we allow, we'd like to, minutes.
That's, again, summarize the indictment, motion to quash, and track the statute. Gave the right that was violated. We're told that was done by the arrest, search and seizure when it wasn't in due course of law. So there's adequate notice in the indictment. The motion to quash is at point of error number 7. That was done on the day of trial, was timely. This code of couch in terms of the motion to sever is trying to get the judge to order us to amend an indictment, which I don't know. But that's a motion to quash as well. It would fail for the same reason. The first point of error, 12 jurors, not constitutional error, would be analyzed. Anything on harmless error, which is again not reserved as constitutional error anyway. Until we got to this point. Yeah, unless you have some questions. Thank you so much for the time and for coming to Austin, Texas. We appreciate it.
Being here. Council, you have additional 5 minutes for it.
Just briefly, would like to talk about the facts of the case. Make it clear that Pellet was the last officer to arrive, was not present for a vast majority of bids that were on videotape. For the other 2 officers, the other 3, the third of which is his boss, the chief of police. He arrives and his chief of police is arresting an individual and orders him handcuffed. Appellate's actions in this case were the placing of handcuffs on him at the direction of his chief. That's it. He is held accountable under the law of parties, under the state's theory, of the knowledge or lack thereof of all other officers that are conducting the investigation, the detention, and arrest. And he's held accountable now to a subjective knowledge that what he's doing is in fact unlawful. That's the slippery slope. That's where you get into how in the state, I think, was candid when they tell the court it's impossible for them to prove that he knew it was unlawful. Now, I would say that's not true, because plenty of times you have a statement by an individual that says, yes, I know it's illegal, but I'm doing it anyway. I'm arresting you. I'm taking you to jail. And there's great protest. I don't care, I'm taking you to jail. Now that would clearly show an officer realizes what it's doing is unlawful. That's not what we have. State, in its argument, as the court, is criminalizing constitutional violation. He said that at the time, as the court said, if it were determined to have been an unconstitutional detention. If that officer should have known that, it's a criminal act. Read the record. The record will reflect the complications and nuances in this area. Detention, entry of a home, exigent circumstances. Their expert was on the stand for a day. Well, they had two experts, 2 days. The court asked, looking back at actions and determining knowledge, what's the difficulty? The Supreme Court's talked about that. Use of force cases under official oppression cases, it specifically states you cannot money more quarterback what's going on at that time. It's split. It happens in a vacuum, close in time. That would be analogous to any future analysis of months later, years later, that this court determines is an unconstitutional search for detention. Therefore, the state then says, well, it must be criminal, and he should have known it. Because all the case law was there. That's difficult, and that's the danger. As far as the jury formation, I do want to address the waiver and the objections. Record volume 8, page 28 through 30, talk about that, and it's clear that we were objecting to the formation of the jury. There's no question about it. There were conversations off the record, but until this time, and right before this time on the record, as is reflected, the court had not indicated that it would be a 12-person jury. We had no way to fathom that the court would then decide that that's the way he was reading the statutes. The Constitution is clear. The state suggested that historically, prior to the amendment of the Constitution, that misdemeanors in district courts were 12-person juries. That's not the case. That's not true. The statute has always been there. The legislature thought it was important, and with the amendment had to be on the ballot, that it was so important that it needed to be part of our Constitution and incorporated as a constitutional right in 2000. But before that, historically, it was still formation of a 6-person jury, high statute of a misdemeanor in district court. It always has. As far as the waiver, the state would have me and any trial lawyer object repeatedly each and every time, all the way to trial. It's clear. The court is clear. And I'll read from the record. I state, and just for the purpose of the records, after the discussion about the 12-person jury as opposed to 6 in the 5 cases, I state, just for the purpose of the record, it's the defense understanding the position that misdemeanor trial district court is formation of 6 jurors with strikes of 5 each side. I understand the court's ruling, and I requested additional strikes if that was the court's intention. And there is. The court says, okay, well, as I said off the record, and then I say, just so it's clear, the objection, I say, Your Honor, on the record, for safety's sake, I object. And he states, just so it's clear, the objection is overruled. It will be a 12-person jury. As far as the objection time of seating, I lodged my objection. It was a constitutional error. There was no misunderstanding. The state even asked for 10 additional strikes. Mr. McAfee asked for 10 additional strikes. So that was, there was no question about that. As far as the questioning of jurors 9 and 10, they were not called up on these issues. They were called up on specific issues as far as preempting challenges. I had no questions on those issues.
Up to your time.
Thank you, Your Honor. Again, I appreciate your time.
Counsel, the case presents interesting questions. This is it to the court on the briefs, arguments, of counsel, and the court will be at recess. Again, we thank you for coming to the third court of appeals to present your arguments, and